back?
Yep.
Is Jamie still there?
He can be. Do you want him to be there?
Well, Alan wants to finish up on his thing, and I'm going to ask him.
Well, I just brought Jamie on, so you're just going to have to
Yeah,
deal.
I've got him on.
Alan's, go for it.
You know, and it's
All right.
really with the story.
We have to continue our appellate update here. Putting the microphone in position. Bear with me. Thank you very much. Okay.
Bum, 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 bum.
Bum, 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 bum. All right, so we finished up with the case of People versus Hannigan before. I should mention that case if you want to read it. It's case number 339239. Okay, the next case we're going to cover is Court of Appeals case number 335493, dated February 27th, 2018. It's Vernon Proctor versus Lara, Department of Licensing and Regulatory Affairs. It's also an unpublished case.
Many patients know Dr. Vernon Proctor.
Yes.
I know.
Well, he appeals
He's my doctor.
this case. This is his appeal because the Court of Claims dismissed his complaint against Lara. And what had happened was Lara decided they were going to stop accepting his certifications from him. From June 15th, he was informed that they were no longer accepting any certifications from him. And the problem was when they called him to verify the certification, they would only give him the patient's name and date of birth. And he says, well, for security purposes, I don't get that. I want you to tell me the date that the certification was signed.
Dates of
also.
service.
Right. What date was the certification signed? And Lara refused. So he was a little reluctant to go along with that. Anyway, so for about 3-4 weeks from June 15th into July, they stopped taking his certifications. There was like 71 patients who refused. So he sued on this. Eventually, he managed to figure out a way just to certify with what they were giving him, date of birth and name. So
That had to be expensive.
He probably had to refile.
See, that's bullshit because the HIPAA statute requires dates of service, allows them to require dates of service.
Well, anyway, he had 71 people that were denied, that were told they had to get another doctor. And the Court of Claims decided that we're going to dismiss this case because once the doctor on his own decided to do what he had to do to get these things going through again and organizing by date of birth, they started accepting his certifications again. So that's
Well, that is ridiculous. What about the damages that he sustained as a direct result of Laura's actions?
Yeah.
Those 71 patients that had to go to other doctors. What about those? What about those losses?
They said
that doesn't sound like it's moot to me.
He said the injuries were not likely to reoccur, so they would, they said this thing was moot. Yeah.
Professionals subject themselves sometimes to the whims of their professional bureaucracies and associations.
Yeah, and it's a 4-page opinion. It doesn't really say too much. All right, the next case we're going to go to is People versus Selman. We already mentioned that he tragically died about 2 weeks ago. This opinion came out March 1st, 2018, so he'll never know, unfortunately, that the Court of Appeals unfortunately affirmed his opinion. This case goes back to August 6, 2010, when the police were informed that he might be growing marijuana in his backyard. And apparently they could see these plants from the street that he'd placed on his back deck of his house, which was enclosed by 4 sides, but I guess the plants maybe were peering over the top. And so they went and they had a talk with him, and he invited him in and said, yes, I'm a patient. And he had 14 other plants in his grow room, and he was also a caregiver for somebody, so he was below his allowable plant counts for Section 4 immunity. He was also below the allowable amounts of usable marijuana. The only dispute was that he's got these 4 plants on his back deck, and for that reason, this is why he gets arrested. And they're claiming that was not an enclosed lock facility. Now, he says that he put these plants on his back deck to spray them for spider mites. That's what's right here on page 1 of the opinion, and I accept that as true. But I also want to just point out that somebody gave Mr. Selman really bad advice on removing his 4 plants from his grow room, just take them outside to spray them for spider mites. And if
I don't think he relies on a lawyer's advice.
No, somebody gave him bad advice, a horticulturalist.
Yeah, he relied on the advice, on the safety instructions on the bottle of
Well, whatever.
might decide.
Whoever gave him that advice, even if it was from a bottle, was bad advice. He should have gone out to Grow Green in Whitmore Lake, and they would have given him something organic that he could spray that wouldn't hurt his plants. And not only that, with spider mites, it's going to spread like. It's going to spread with spider mites. It's going to spread like bacteria anyway. You can't just, if it's on 4 plants, it's probably going to be in his whole grow room anyway. So it really didn't make much sense to take these plants outside. And like I said, if you talk to somebody at Grow Green for any type of plant infection, they're going to be able to help you there. They're the
It
best
makes
people.
a lot of sense to take plants outside. I am just going to reiterate that.
Well-
It makes a lot of sense to take plants outside to spray them. I
Don't do
understand
it.
how it doesn't make sense under the law only because the law doesn't make sense.
Yeah.
And you can't expect the law to make sense at this point because there are assholes in the Court of Appeals
Yeah.
that are trying to make it not make sense for regular people.
All right. Well, anyway, he was denied Section 4 immunity because they determined that this back deck, that even though it was enclosed on all 4 sides with wooden slats and it had a lock on the door to his house and there was also a lock on the door to the back, they still said that it was easily accessible, that anybody, because there was no roof on the top or anything, anybody could climb over these slats to access to these plants which were seen from the street. So they said it was not an enclosed and locked facility, so they denied him Section 4 immunity on this case. Folks, if you're reading this at home, I encourage you to go to page 5 on this where they talk about his Section 8 immunity, or Section 8 affirmative defense, rather, and why he was denied that. Again, this is case 333484. You can pull it up from the Court of Appeals website. But anyway, on page
And the
5...
Northwestern Reporter citation, please,
It's,
in case they're following along in the Northwestern
it's,
Reporter.
it's an unpublished case.
Second edition.
Will not have a Northwestern Reporter case. There will never be one because it's an
Okay,
unpublished case.
never will be there.
Never,
so
never. All right.
You guys will miss it.
Now, the problem I really have with this case, when they talk about the Section 8 affirmative defense, is they have it all wrong. And I just want to know what these
Section
judges...
8 affirmative defense?
Correct.
Now you were giving an opinion about Section 4.
Yeah, that's the opinion does address Section 4 immunity first.
Are you going to talk about Section 8?
We're going to talk about both. First, we said he was denied Section 4 immunity because his back deck was not an enclosed locked facility under what they determined, because they determined anybody could hide more. The slats weren't high enough that anybody could hop over that to have access to his plants. And since he's the only one who's supposed to have access to his plants in an enclosed locked facility, he was violating that aspect of Section 4, and they denied him Section 4 on that basis. Now, in Section 8, originally, the trial court judge said, yes, this is going to go to a jury. That he had his Section 4 hearing, and, that was great. So he'd at least get a chance to argue his affirmative defense to the jury. Unfortunately, this is an Oakland County case, and the people, Beth Hand, appealed this to the Court of Appeals, which initially denied leave. But then, unfortunately, they asked the Supreme Court to review it, and the Supreme Court held it in abeyance while Hartwick and Tuttle were pending. Once Hartwick and Tuttle came down, the Supreme Court looked at this case again and said that the Oakland County Circuit Court was wrong. And they did this on their own. Rather than remand it to the Court of Appeals, they said the Oakland County Circuit Court was wrong, that he didn't put in all of his elements of Section 8. He only put in first element and third element, and so for that reason, he was not entitled to assert his Section 8 affirmative defense at trial. Okay, so now what happened
And
here...
was convicted
Yeah,
by a jury.
eventually, but I haven't gotten there yet.
I don't know if that's necessarily true. I think he had problems with, he won on all 3, and the appeal was based on the bona fide doctor-patient relationship in that he
Okay.
didn't have his patient testify at the Section 8 hearing.
That's
that
correct.
could be. All I'm telling you, this is what this opinion states.
But you
And
did.
don't-
You had the procedure correct as
Right.
it was going through.
Right.
That was really
and
remarkable.
Michael,
That was
I don't
really-
doubt that you're right and this opinion's wrong, because I want to go on another part right now where this opinion is dead wrong. All right, and if you go to page 5,
But Alan, you're talking about the Section
For those
4
of you
reversal,
following at
and the
home.
discussion about Section
Page 5.
8
right?
is not really the meat of this case.
They're not on page 5, Alan. I'm sorry.
Okay, but
You got to explain it to the people
I know,
in
but
Radio
see,
Land.
people are entitled to assert both offenses at court: the Section 4 immunity and Section 8,
I want-
and that's what he did.
I understand.
And I'm telling you why Section 4 was denied was because they determined his backyard
Sure.
deck was not enclosed. Now I want to move on to Section 8.
Fine, go
Okay.
ahead.
Here we
Page
go.
5. Thank you very much. All right. So, I'm going to read. I have to read from this opinion. It's a second full paragraph on this page because it's so dead wrong. It says a trial court's decision to hold an evidentiary hearing regarding whether a defendant is entitled to assert affirmative defense under Section 8 of the Medical Marijuana Act is reviewed for an abuse of discretion, and they cite People versus Unger. Well, there's two problems with that. Number one, a trial court has no discretion whether or not to hold a Section 8 hearing. If a person files that motion as a pretrial motion and asks to assert that, the court must hold that hearing. That's Hartwick and Tuttle. If they put, so that's the first.
You ever heard of the case People versus Trost?
Yeah, okay. Let me continue here. Trost is a more recent case. We've got Watkins number 2 from
No, I'm saying
2011.
they were
I know
denied
Trost.
trial court
I know,
without being able
and
to
they
have
did
a
that in
hearing.
this case too. They also denied him talking about the Medical Marijuana Act and the defenses. That's we haven't gotten there yet. We're still trying to talk about Section 8. The problem is with this, as I said, number one, if a person asks for a Section 8 hearing, the court has to grant it as a pretrial motion, hold the hearing, and the title determine if they're going to be able to present the Section 8 defense at trial. And that's what he did in this case. But what they said here is the decision whether or not to hold this evidentiary hearing is reviewed for abuse of discretion. That's wrong. And the case they cite for that is People versus Unger, and it's 278 Mishap 210, and the year of this case is 2008 in the citation. Now that should have told somebody right then and there they've got the wrong citation for this principle that they're stating of law, because 2008 there wouldn't have been an appellate case on the Medical Marijuana Act. The Medical Marijuana Act didn't even become effective till December 4th, 2008. This Unger case was decided March 2008. So they put the wrong damn case in here. Number one, to cite a principle law that's wrong, because, as I said, a trial court has no discretion whether or not. If you assert that in a timely pretrial motion, they've got to hold a hearing. What they were trying to say here in this case was that after this came back from the Supreme Court, the defendant asked to reopen the proofs on a Section 8. And I think that's what they were reviewing with under an abuse of discretion standard. But they don't say that here. Their language here is very muddy, and they muddy it up even more by having a case which was actually a first-degree murder case.
I'm very aware of it. You know why?
And as Unger, you know the people from Honey?
I know the decedent.
Okay.
I used to do spinning with her at Beverly Hills Racket Club.
Yeah, all right. Well,
She's going through a divorce with her husband. They went away for a
right,
weekend.
2003. Yeah, she
Someone
never
fell
came
up.
back.
Right,
Yeah.
it fell up.
She got convicted. So anyway, but the fact is that they cite this case for a principle law. It just shows you how asinine this whole opinion is. So take this opinion with a grain of salt. But anyway,
I thought you were going to say and shove it up your ass, but
well,
Take this opinion and turn to page 6 and focus on the third paragraph.
yes, very
page 6,
good.
the third paragraph. I'm going there now. Anyways, that's what I was saying, Chad, before that they found that he'd only established the first and third elements of Section 8, but the second was in dispute. All right. The other thing that they did at this case to this guy was they prohibited him from testifying about the Medical Marijuana Act or anything about his use or
Standard
kind of what they
operating
did.
procedure at Oakland County.
What they
unfortunately.
did, the same thing that they did to him that they did to try to do to Peter Troes recently.
What happened in that case?
Well, in that case, the Court of Appeals partially reversed it, but not enough. If you look
what
at
happened? What happened? I guess.
with Troes,
Yeah, give the opinion.
well, with Troes, it was the same thing. The prosecution filed a motion in limine to prevent the defendant from talking about the Medical Marijuana Act or any of the things. Well, the Court of Appeals.
Yeah, they fucking do that every time.
Yeah, but
assholes.
But they can't. And that goes back to People versus Watkins, which is from 2011. I could bring that up right now. I want to give everybody a cite to that because
Yes,
Different owners got their blue
definitely
book out.
cite it.
hey, it'll take me just half a second.
So here's what's really going on. Can I just say this?
Go ahead.
Give me 15 seconds. So
You get
this
30
isn't-
seconds, Shirley.
Oh, thank you so
Okay, here it
much,
is.
Jim Powers. So this is actually a campaign that was told to us in September of 2010 by Catherine Mish, Grand Rapids City Attorney Catherine Mish. She said, "We need test cases. Nobody knows what an enclosed locked facility is. Please go bring us these test cases." They were looking for cases to challenge and do this too. It's a political strategy. He didn't do anything wrong. This man didn't do anything wrong, and he died during this process. He was incredibly sick.
They tortured him for years.
They tortured him for years.
All right, getting back to Troes in these other cases, this goes
true,
back to
Alan.
people.
Alan,
what
don't deflect.
But what they're trying to do is stop people from talking about the Medical Marijuana Act when they're in
luck.
court, and the prosecution filed these motions ahead of time saying that you can't talk about the Medical Marijuana Act, and they did that with Mr. Selman. They did that with Mr. Troes and said that he couldn't
Yeah,
talk
but come
about
on,
that.
argue at the
Trying to
Court of
bar back,
Appeals,
bro.
and we got a ruling that they can't do that. That it's part of the res gestae, and they